21516-FH, People of the State of Michigan versus Donald Raymond Lester. We are here today for a final pretrial conference in this case ahead of a trial scheduled for June 20th and 21st. We are proceeding today partially in person and partially by video conference. First, let me have the attorneys place their appearances on the record, beginning with Ms. McClure.
E.B. McClure filling in for prosecutor of record Isaac Sneed.
Samaris Hennigan on behalf of Donald Lester.
All right, and Mr. Lester, I believe, is in the jail Zoom 2 device. Mr. Lester, are you there?
Yeah, I'm here.
All right, so I don't know what's going on with the camera. We can't see you. It looks to be shooting at the almost. I'm saying that we can't see you, Mr. Lester. So, Ms. Hennigan, where do we stand? Are we ready to proceed to trial on June 20th?
Thank you, Your Honor. I met with my client yesterday and did make the final offer to him with regard to plea agreements. My client has declined to accept the plea that was offered by prosecution. I also was informed by my client that he has filed a few motions, I guess you would say pro se. I have not seen those motions myself, but he says he mailed them to the court. He does have many objections to the proceedings. That being said, the next step that would be appropriate with regard to our legal procedures would be to go forward with trial. I am prepared to do that, though I do believe that my client will object to that, Your Honor. So I do want to make sure that I represent his wishes as well, while I still inform the court of whether or not I'm ready to proceed. So I will be ready to proceed for trial next week. That being said, my client does not want to go to trial as he feels that the court doesn't have jurisdiction over him on this matter in order for us to move to trial. And he was very upset. I would add, just for the record, for his for appellate purposes for him, that he was upset that I agreed to a trial schedule at a past hearing. And I did try to explain to him that that's just a procedure, that the court is on timeframes according to statute, and that at some point we do have to set a trial schedule, even though it was my intent to continue to try to negotiate this case for him along the way.
All right, to the extent that there's any objection based on court's jurisdiction,
I can't hear you. Can you speak up, please?
To the extent that there's any objection to proceeding to trial based on the court's jurisdiction, I would deny that, as the court does have jurisdiction over this case. It is a felony case involving an alleged felony which is alleged to have occurred within Lenawee County, state of Michigan. This is the circuit court for the Lenawee County, state of Michigan, and therefore jurisdiction is appropriate. Ms. McClure, is there anything we need to address from the people's side?
The people have not received any motions that have been referenced, but as far as I know, we are prepared to proceed to trial next week as well.
Right.
All right, so do we have proposed jury instructions and voir dire questions yet?
We do not, and I spoke with Mr. Sneed yesterday, but I'm certain that we can agree upon those within the next day or so.
I see some in our file, so maybe he's drafted them and just not.
Yes, he was working on them.
Okay, so I'll need those by the end of the week so that we have an adequate amount of time to get prepared for trial.
I would also like to intervene here real quick, but that being said, the motion is just not for the jurisdiction, it's also for personal jurisdiction and subject matter jurisdiction. I had the right to a resisting unlawful arrest, and it's not being addressed. The Supreme Court ruling on that, I just read that not too long ago, and they arrested me for an old traffic ticket, is where it started at. They're trying to dodge the point of where they harassed me for 3 days before they arrested. And as far as this possession situation go, I was informed yesterday by my attorney, who I haven't talked to since March, that I was looking at 14 years. Under your court, Michigan rules that after 10 years, under a lower felony, after 10 years, it's automatically expunged. So I'm trying to figure out how am I being charged with a habitual criminal. And also, I would like to get that in writing, that you said that you have jurisdiction over this case, but not the said person. And that's all in the motions that I sent over to the clerk's office. I also have them all notarized. I also have copies of everything that I sent over there. So there should be somewhere in y'all file that y'all should have it.
Your Honor, I did.
And personal. And like I said, I haven't talked to this woman since March. She told me that I was going to be released out for bond, and I haven't heard anything from her since then. I wrote her a letter. The first time I seen this woman in about 2 or 3 months, his first time was yesterday. And she doesn't represent the said name anyway. I've talked to her about that situation too. Somebody's not being truthful here. And I've been sitting here almost 10 months without a bond or even so much as calling my witnesses. She's never asked me anything. So my due process is being violated. Also, I'm sitting in here on an unsigned warrant. Unsigned. A probable cause warrant. They're trying to make it look like they arrested me for those charges, and that's what it's not what it was for. That's not what it was for. I was arrested for driving on a suspended license from back in 2016. That case got dismissed.
Your Honor, I did inform him
He's not
yesterday.
addressing none of those issues, Your Honor, period.
Mr. Lester, I need you to stop interrupting people, okay? What is it that you wanted to say?
I did inform him yesterday that the charges he was facing could, that it's up to 14 years because there's consecutive sentencing available on those charges. He has a felony that is up to 10 years, and then 2 R&Os, which can be sentenced consecutively if that were requested and or if the court were to do it. And I informed him of that at the time that I was telling him about the plea agreement that would allow him to be released today. So he is correct in that I did inform him of that, but it's not because of the habitual offender notice. And he asked me about that yesterday, and I reiterated again yesterday that that is not why. That is not why he's facing that amount of time. It was simply me telling worst case scenario in this matter.
All right, so to the extent that personal jurisdiction issue has been raised in addition to subject matter jurisdiction, and again, deny any request on those bases because the court, again, has personal jurisdiction over Mr. Lester, who is a human being located in Lenawee County, Michigan, and alleged to have commit a felony crime in Lenawee County, Michigan.
How did I commit a violent crime?
With respect to the argument that Mr. Lester made regarding the right to resist an unlawful arrest, that's why the court is having a trial. One of the elements that the prosecutor needs to prove in a resisting and obstructing case is that the officers were on duty, acting lawfully, and made a lawful arrest that Mr. Lester resisted. So that's the purpose of the trial. With respect to any issue about expunged convictions, we're not even to that point yet. The habitual offender issue comes into play only after a conviction has entered, and then the court has to determine whether the convictions listed in the habitual offender notice in fact happen and can appropriately be used under the statute for the sentencing enhancements that have been notified in the information. And so
okay, so whenever you get done, I'd like to address the issue too, please.
All right, I'm going to mute Mr. Lester because I can't have people talking over me while I'm trying to create a record. All right, so then we are ready to proceed to trial on June 20th. Again, I'd like to have the voir dire questions and jury instructions ready or by the end of the week so that we can have those ready to go.
Thank you, Your Honor.
Yeah. Before we go, can I address?
Ms. McClure, can I just understand from you what that final offer you made on this case, or what the final offer the prosecution made on this case was?
Yes. It would be,
Ms. McClure, I actually have a copy that I could pass to the court too, if that's okay with you.
yeah, I mean, we'll just take a second. It's an added count for possession of meth in a park, which is a 2-year offense. And we were offering credit for time served, which is approximately 10 months, and we have no objection to a PR bond at the time the plea is taken.
Ms. McClure, could I just add that Mr. Sneed did inform me that you had authority to do fines and cost only on this as well?
No.
That be accurate?
I think, yeah, I think that would be part of the credit for time served.
Thank you.
So the prosecution has made an offer to resolve the case if Mr. Lester were willing to plead guilty to possession of methamphetamine in a park. That's a 2-year maximum possible penalty, but the prosecution has also agreed to credit for time served and or fines and costs and a personal recognizance bond release until the date of the sentencing. Is that all accurate, Ms. McClure?
How is that? That
Yes.
is crazy.
Yes,
All
that's
right.
accurate, Your Honor.
And Mr. Lester is not interested in agreeing to that plea. Is that correct?
It's my understanding, but it seems that he would like to say something about it, Your Honor, so I prefer that he answer that question himself.
I would like to say something because of the fact that you keep trying to let me out on a PR bond and you want me to come back to court for sentencing, but you won't let me out to try to get my witnesses and gather the evidence that I need to be able to present it at trial. I haven't even went over this one. I haven't even went over any kind of defense with this woman. I am being prosecuted and persecuted by her and a prosecutor. And it's obvious. It's very obvious. It stands out. I haven't talked to this lady since March. And when I did, she came in there and coerced me into trying to keep her on my case.
All right, so Mr. Lester, that wasn't really responsive to the question that was asked. The question you're being asked
I don't know
right
nothing
now.
about that. I told her what it was then, and
Mr. Lester,
you keep trying to cut me off.
well, that's because you won't let me create the record and do my job. So I'm
trying to do my job. You're not the one sitting in jail, sir.
All right, so Miss
Your Honor, would you
All right,
please
so
mute
the-
my client? I don't want him to.
record
Find
should
yourself in
reflect that. The record should reflect that Mr. Lester had, I'm sorry, so Mr. Lester, the question I'm asking and that I need an answer to is you've heard the offer that I've indicated the prosecution has made to you to resolve the case. Do you or do you not want to?
No, I'm not, because they had no business arresting me, Your Honor.
And
I wasn't bothering anybody.
A simple no is fine. That's all I needed. All I needed was no.
Quit talking to me like I'm a kid.
The answer is no, so we will proceed to trial next week. I don't think there's anything else we need to address this morning. So Mr. Lester,
I need a
let the
bond.
officer know that you are done with court.
See what I'm saying?
All right, Ms. Hennigan, are you ready to proceed with?
Yes, Your Honor, I am.
As I locate his file, will you do that? All right, we are on the record in file 24-21834-FH People versus Harold Glenn Tate Jr. We are here today for an arraignment. In this case, we are proceeding today by video conference. First, can I have the attorneys place their appearance on the record, beginning with Ms. McClure.
Phoebe McClure on behalf of the people.
Mayor's Hennigan on behalf of Mr. Tate.
All right, and so this is an arraignment. Ms. Hennigan, does Mr. Tate wish to have the information read?
No, Your Honor, we would waive the reading of the information.
All right, and you know how Mr. Tate wants to plead today?
He's trying to enter a plea of not guilty this morning. And he asked that this be set for a pretrial as well as a bench conference with Judge Anselon when she returns.
So I'll enter a not guilty plea for Mr. Tate. Ms. McClure, anything we need to address from the people's side today?
No, Your Honor.
Your Honor, if I could just for the record indicate that my client informed me that Mr. Coase was over to see him regarding bonds prior to this hearing. And my client is currently serving a sentence for Hillsdale County. And so we're not asking for a change in his bond at this time, as he's, that would not be beneficial to him right now.
Okay. Francis or Sierra, do you have dates for Judge Anselon for a pretrial conference?
Yes, I do, Judge. July 3rd at 8:30.
Okay. We'll enter a not guilty plea for Mr. Tate and set it for a pretrial conference on, I'm sorry, did you say July 3rd?
Yes.
July 3rd at 8:50.
8:50 or 8:30, Your Honor?
8:15.
8:15. How about, thank you.
8:30.
I'm sorry, 8:30. All right, anything else we need to address today?
Oh, no, thank you, Your Honor.
Okay.
So, Tamaris, if you want to reach out to Miss Adams and get dates for a bench conference, just loop me in on it so I can be present too.
Thank you, Ms. McClure.
Okay, thank you, Mr. Tate. You can let the officer with you know that you're done with court for today.
All right, thank you.
I'm ready.
Okay, Mr. Dagger Rogosian, I think we're ready for Mr. Taylor now.
Okay.
All right, we are on the record in file 22-21115-FH, People versus Dante Roy Taylor. We are here today. This is a continuation of the pretrial conference. I do now have the amended information. With the added count of operating while intoxicated. Anything else we need to state on the record before I swear Mr. Taylor in?
No, Your Honor.
All right, Mr. Taylor, do you want to raise your right hand? Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth under penalty for perjury?
Yes, sir.
And you are Dante Roy Taylor, is that correct?
Yes, sir.
Mr. Taylor, you've heard the statement of your attorney and the prosecuting attorney. Is it your intention to plead no contest today to count 3, reckless driving causing death?
Yes, sir.
Do you understand that the maximum possible penalty for that offense is up to 15 years in prison and or a fine of $2,500 to $10,000?
Yes, sir.
Do you understand that it also requires mandatory vehicle immobilization unless that vehicle is forfeited?
Yes, sir.
Are you satisfied with Mr. Dagger Margosian and the advice he's given you?
Yes, sir.
I'm sorry, I also forgot to ask, is it your intention to also plead guilty today to count 4, operating while intoxicated?
Yes, sir.
Do you understand that the maximum possible penalty for that offense is up to 93 days in jail and or a fine of $100 to $500 and or 360 hours of community service?
Yes, sir.
And are you satisfied with Mr. Dagger Margosian and the advice he's given?
Yes, sir.
Other than, as we've discussed on the record here today, neither the prosecutor, defendant, or anyone acting on the defendant's behalf has discussed a possible sentence with the court. Is that correct, Ms. McClure?
That's correct, Judge. I just wanted to place on the record that we do have the sentence agreement of 12 months, and that would be for the court's edification that is below the guidelines, which I have preliminarily calculated at 19 to 38. So just so the court's aware that the sentence or the agreement is below the guidelines. So the court always has the option to not impose that, but I just want to make sure that's on the record.
All right. Thank you for that. And obviously, if the court for some reason were to not do that, Mr. Taylor would have the right to withdraw his plea at that time.
Yeah.
So, all right. So is that also your understanding, Mr. Dagger Margosian?
It is, Your Honor.
Is that your understanding as well, Mr. Taylor?
Yes, sir.
If the guilty plea is accepted, Mr. Taylor, there'll be no trial. That means you'll be giving up the rights that you would have had at trial. I'm going to explain those rights to you now to make sure that you understand them. You do have the right to a speedy public trial by jury. You could ask for a non-jury trial, and if the prosecutor and the court agreed, you could have a non-jury trial. You have the right to be presumed innocent until proven guilty beyond a reasonable doubt. You have the right to have the prosecuting attorney prove beyond a reasonable doubt that you are guilty, and you do not have to prove anything. You have the right to be present at your trial, to have the witnesses against you appear at your trial, and to ask those witnesses questions. You also have the right to have court order any witnesses that you have for your defense to appear at your trial. You have the right to remain silent during your trial and not have that silence used against you. However, you also have the right to testify at your trial if you wanted to testify. Do you understand, Mr. Taylor, that if your plea is accepted, you may be giving up the right to appeal issues that would otherwise be appealable if you were convicted at a trial?
Yes, sir.
Do you also understand that any appeal from the conviction and sentence pursuant to your pleas would be by application for leave to appeal and not by right?
Yes, sir.
If you are not a citizen of the United States of America, conviction of a crime can result in deportation, exclusion from admission to the United States of America, or denial of naturalization. Do you have any questions about any of those rights, Mr. Taylor?
No, sir.
Do you understand that you're giving those rights up?
Yes, sir.
How do you wish to plead to the charge that on or about May 22nd, 2022, in the township of Franklin, county of Lenawee, that you did commit the offense of reckless driving causing death?
No contest.
And how do you wish to plead to the charge that on or about May 22nd, 2022, in Franklin Township, Lenawee County, Michigan, that you did commit the offense of operating while intoxicated?
No contest.
Has anyone made any threats or promises to you, Mr. Taylor, to induce you to plead no contest to those offenses?
No, sir.
Do you understand that if I accept your pleas, you'll be giving up any and all claims that the pleas were given as a result of threats or promises that were disclosed to court on the record this morning, or that it was not your own choice to enter the pleas?
Yes, sir.
Is the prosecutor or defense counsel aware of any promises, threats, or inducements other than the plea bargain to induce Mr. Taylor to plead guilty?
None, Your Honor.
No, Your Honor.
Mr. Taylor, other than as we've talked about it on the record here this morning, has your attorney promised you any other particular sentence or estimated what your sentence would be?
No, sir.
Is it your own choice to plead no contest today?
Yes, sir.
All right. How will we be establishing the factual basis?
Your Honor, I have the main police report. I can pull facts from that if Ms. McClure is fine with that as well.
Yeah, I have no objection to that. Also, the basis for the no contest plea, I just want to make sure that's on the record. I assume it's lack of memory and intoxication.
As well as civil liability, but yes.
Okay, I just want to make sure we had that, but I have no objection to the police report, the lab reports, and or the preliminary exam transcript.
Okay, then, Mr. Dagger Margosian, you can proceed.
Your Honor, as Ms. McClure indicated, there are a handful of documents from this case. I guess what I'll mainly draw from is the police report 2200049009-001, authored by Christopher Van Dyke. In that report, as well as the lab reports, as well as the preliminary exam transcript that was conducted earlier in this case, Mr. Taylor was operating a motor vehicle at in Franklin Township in County of Lenawee, State of Michigan. During that operation, Mr. Taylor, regarding the count 3 reckless driving portion of this, the manner of driving was willful and or wanton, and due to that status of driving, there was a death of Brandon Walker, who was a passenger in the same vehicle. It was a single car crash. The vehicle did go off the road due to the willful and or wanton disregard for the safety from Mr. Taylor's operation of that motor vehicle. And then I'll just go to count 4, and if Ms. McClure has follow-up, that's fine with me as well. For count 4, again, it's really the same course of conduct. We would stipulate and agree that Mr. Taylor did have active THC in his blood. The blood draw for alcohol was 0.05, obviously under the legal limit. However, that in combination or simply the THC would qualify as OWI.
All right, Ms. McClure, anything to add from the people's side?
Yeah, Judge, I just worry that the statements made are a bit conclusory. I would just ask for additional facts. If there's no objection, I can place them on the record, but additional facts that support those conclusory statements.
Right, so why don't you proceed with the facts you
Yes.
believe to be necessary, then I'll ask Mr. Dagmar-Gosian if he agrees with those.
Mr. Taylor was operating on US 12 and in the area of Sharon Hollow Road. At that time, he was driving at a high rate of speed. It was shown by accident reconstruction, and failed to negotiate a curve, and ended up off the road, causing a crash that did cause the death of Brandon Walker. At the same time, while he was operating that vehicle in that same area, he not only was 0.05 VAC, but he also had 11 active nanograms of THC in his blood. And that was in lab number 227997, records 1 and 2.
Doesn't seem like it's me.
No.
All right, Mr. Dagmar-Gosian, you agree to the use of those facts as support for the factual basis?
I do, Your Honor. It expands on my initial recitation, but I do agree, Your Honor. Thank you.
Has the court complied with MCR 6.302 BC and D, Ms. McClure?
It has.
Yes, Your Honor.
Mr. Okay, I'll accept the pleas then. They've been given understandably, voluntarily, and accurately. Mr. Taylor has had full knowledge of his rights to have competent counsel. The court's not made any agreement other than as we've discussed it on the record here this morning regarding the possibility of a plea or sentence in this case with the prosecutor, defense attorney, defendant, or anyone acting in the interest of any of them. I will refer this matter to the probation department for a pre-sentence investigation. We can set sentencing for July 12th at 8:15 a.m. Mr. Taylor, someone from the probation department is going to be in touch with you to do a pre-sentence investigation interview. When you do that interview, please be truthful about these offenses and about your background.
And Judge, Mr. Taylor at this time is residing out of state. I would just ask that, and I think Mr. Dagmar-Gosian's told him that he be present for sentencing.
Okay, and yeah, Mr. Taylor, you're going to need to be present in person for the sentencing hearing.
Okay.
And if you give me just a moment, I just want to confirm that we have fingerprint information. Yeah, we do. So we're all set there. Okay, so
Your Honor.
yeah.
I imagine the reason Mr. Coase is on screen is there is an outstanding bond situation. I would just ask the court to maybe adjourn that until the time of sentencing, and I think at the time of sentencing it will resolve itself.
And Judge, I'm totally fine with that. I mean, he's done pretty well with the PBTs. He is late on several of the morning blows though. So I do need him to be on time for those morning tests.
Yes,
All
sir.
right. Okay, so we'll adjourn the contempt or bond issues to the date of sentencing. Mr. Taylor, I'm going to place you in a breakout session with Mr. Stevenson from the probation department so that he can collect your contact information in order to do that pre-sentence investigation interview.
Okay.
Your Honor, could you put me in that breakout room as well, and then I'll just
sure. Yeah, give me just a second.
Thank you.
And Mr. Dagmar-Gosian, if you haven't forwarded that signed plea offer, will you do that?
Sure.
Thank you.
Okay, the gentleman that is at the Lenawee County Jail, can you tell me your name, please?
Benjamin Johnson.
Okay. All right, we are on the record in files 20-20088-FH and 21-20255-FH, People versus Benjamin William Johnson. We are here today for arraignment on warrants for probation violation. In these cases, we are proceeding today by video conference. Sir, you are Benjamin William Johnson?
Yes.
Mr. Johnson, have you received copies of the warrants yet?
No, I have not.
All right, is there an officer there that's with you?
No.
Can you step out and see if you can get someone's attention and let them know that you need copies of your warrants? Okay, were you able to find someone, Mr. Johnson?
Yeah, they said they're gonna get them for me.
Okay, so while they're doing that, I will let you know that the warrants allege that you violated the conditions of your probation by testing positive for fentanyl, methamphetamine, and amphetamine and morphine on June 7, 2024. In the 20-20088 case, you had pled guilty to attempted possession of methamphetamine as well as operating while visibly impaired. The maximum possible penalty for the attempted possession of methamphetamine charge is up to 1 year in jail and or a $1,000 fine. The maximum possible penalty for the operating while impaired charge is up to 93 days in jail and or a $300 fine and or 360 hours of community service. In file 21-20255-FH, you had pled guilty to attempted retail fraud first degree. The maximum possible penalty for that offense is up to 2.5 years in prison and or a $5,000 fine. You do have the right to be represented by an attorney here today and at any other proceedings that we have regarding these matters. If you can't afford an attorney, you can tell me that and I'll appoint one for you at public expense. Do you understand that?
Yes.
Would you like to be represented by an attorney?
No.
Do you understand that you have the right to contest these violation of probation charges and to have trials on them?
Yes.
Do you understand that throughout the trial, you would be presumed innocent until your guilt is proven by a preponderance of evidence?
Yes.
You have a right to have all of the witnesses against you appear at your trial. You or your lawyer could ask those witnesses questions. And you also have the right to have me order any witnesses that you have for your defense to appear at your trial. Do you understand all of that?
Yes.
You are not required to testify at your trial, and no one can say anything about you not testifying or hold that against you in any way. You understand that?
Yes.
On the other hand, you have the right to testify at your trial if you wanted to testify. You understand that as well?
Yes.
How do you want to plead to the charges that you violated the terms of your probation?
Guilty.
I'm sorry, the audio was a little bad. What was that?
Guilty.
Okay. Do you understand that by pleading guilty, you're giving up your right to a trial and your right to have your lawyer's assistance at that trial, as I've already explained?
Yes.
Has anything been promised to you in order to get you to plead guilty?
No,
Has anyone threatened you in any way in order to get you to plead guilty?
no,
If I accept the plea, you'll be giving up any and all claims that the plea were given as a result of threats or promises that were not disclosed to the court on the record today, or that it was not your own choice to enter the pleas. Do you understand that?
yes, I do.
Is it your own choice to plead guilty today?
Yes,
So you were placed on probation, looks like back on December 8, 2022. Is that correct?
correct.
And you were aware that one of the conditions of your probation was that you not use any controlled substances. Is that also correct?
Correct.
And on June 7, 2024, did you do a drug test?
Yes, I did.
And was that positive for fentanyl, methamphetamine, amphetamine, and morphine?
I believe so.
Okay. I will accept those pleas then. They've been given understandably, voluntarily, and accurately. Mr. Johnson has had full knowledge of his rights. He's had competent counsel. Court has not I will refer this matter to the probation department for an update of your pre-sentence investigation and set sentencing for June 21st at 8:15 a.m. Oh, I'm sorry. So this is, Mr. Johnson, this is Judge Angelone's case normally. So she would normally be handling your case. She's not here today, so that's why I'm doing the arraignment. Because it's her case and I did the arraignment, you can choose to go back to Judge Angelone and have her do the sentencing hearing, or you can have me do the sentencing hearing since I took the plea. Do you know which one you would like to do?
I'd like to stick with you.
Okay. So we'll set it for June 21st at 8:15 a.m.
Is that the soonest?
All right. I'm sorry?
Is that the soonest we can do it?
Yeah, I have to give the probation department time to do their updated pre-sentence investigation. And so that's next Friday. I've got to give them at least a week to do that. So that's as soon as I can do it.
Okay, thank you.
All right, so you're all set. You can let the officer with you know that you are done with court for today.
All right, thank you very much.
Thank you.
She was on Zoom. I don't think they're here in person, either one. Francis said she's been.
Yes.
Okay.
I cannot have the hearing, so.
Okay.
Come in. Yeah. Right, we are on the record in files 24-51636-PP, Juan Carlos Avila versus Kelsey Renee Schneider, and file 24-51637-PH Caitlin Elizabeth Lorishon versus Kelsey Renee Schneider. We are here today for arraignments on alleged violations of personal protection orders in both of those cases. Miss, you are Kelsey Renee Schneider. I need you to speak a little louder, please.
Yes, sir.
Thank you. Ms. Schneider, you're here today before the court on an order to show cause. The show cause alleges in the case with Ms. Lorishon that you violated a personal protection order by attempting to make contact over FaceTime on April 20, 2024. The show cause with respect to the case with Mr. Avila alleges that you violated that personal protection order on April 20, 2024 by appearing in a custody exchange. Do you understand that the maximum possible penalty for violation of a personal protection order is up to 93 days in jail and or a $500 fine?
Yeah.
Do you understand that that would be applicable with respect to both files?
Yeah.
You do have the right to be represented by an attorney here today and at any other proceedings we have on this matter. If you can't afford an attorney, you can tell me that now. I'll appoint one for you at public expense. Would you like to be represented by an attorney?
Yes.
Do you have the ability to pay for your own attorney?
No.
All right, so what I'm going to do is appoint the public defender's office to represent you. And what I'll do is I'm going to adjourn this to, can't do next week, but the following week is June 26th. At 8:15, so I'll enter a not guilty plea on both files for you. Appoint the public defender's office, and we'll adjourn the hearing to June 26th at 8:15 a.m. And that will give you time to get in contact with the public defender's office. You'll want to speak to Rhonda Underwood, Ms. Underwood from the public defender's office. She's watching on Zoom right now. Ms. Underwood, is there anything you want to say to Ms. Schneider?
No, Ms. Schneider, if you call our office, you can make an appointment with me and we will discuss this matter and be prepared for your next court date.
Okay, thank you.
Do you know where they're located, Ms. Schneider? So they're we're in what we call the new courthouse. The old courthouse is just across the street. The building across the next street is the public defender's office, right on Front Street. And so you just need to either go over there or call that office to make an appointment with Ms. Underwood.
And that date is the 26th, Your Honor, did you say?
Correct, 2 weeks from today.
Thank you, Your Honor.
All right, so you're all set for today, Ms. Schneider. You're free to go. All right, Ms. Pawson, are you able to hear me? Can you hear me, Ms. Pawson? Ms. Pawson's audio is not connected. If you give me a moment, I will try to help her do that. All right, Ms. Pawson, are you able to hear me now?
Yes, sorry about that. I am Tiffany Adams. I am Janessa Pawson's sister. She is right here. She is hearing impaired, and she's asking that I speak on her behalf.
Okay, so she's not able to hear me?
No, not on the phone. She can't hear. Her car broke down last night. She works midnight. She got off work around 5:30 this morning, tried to drive home. Her car broke down, had to have that towed as well as get a ride home. She didn't end up getting home until about 7:30. She sat down for a second to take off her boots and fell asleep. I did not wake up on time myself either. She couldn't wake up to her alarm. Is there any way that we could have this rescheduled, even if it's just for a couple days?
All right, so what, does she need a sign language interpreter?
No, what she does is when she's in person, she's able to hear bits and pieces, but she doesn't hear everything correctly. Like certain words she won't understand or hear right. So that's the reason I was asking to speak on her behalf.
All right, I can't continue in this format if Ms. Pawson is not able to hear and understand what I'm saying. So what I'm going to do is adjourn this to June 26th at 8:15 a.m. I'm going to require that be in person. So Ms. Pawson needs to be present in the courtroom in person for that hearing.
Okay, just 1 second. Let me let her know. He said that he can adjourn it till June 26th at 8:15 a.m. so you can get the night off work and be there in person to be able to hear. Okay? Thank you very much, Judge. I really appreciate you.
All right, so that's all we're able to accomplish with this case today. I will see everyone back on June 26th at 8:15.
Sounds great. Thank you.
All right, thank you.
Bye.
All right, Mr. Malero, you ready to proceed with Mr. Thompson?
Yes, Judge. Gotta remember what we're doing.
All right, this is file 23-21521-FH, People versus Landon Mackay Thompson. We are here today for a pretrial conference in this case, and we are proceeding by video conference. First, let me ask the attorneys to place their appearances on the record, beginning with Ms. Wagner.
Good morning, Your Honor. Amanda Wagner for the people.
Salvatore Malero on behalf of Landon Thompson. Mr. Thompson, tell the court you're here.
I'm here.
What's your name?
Landon Thompson.
All right, and Mr. Malero, where do we stand with Mr. Thompson's case today?
Your Honor, I believe we have a resolution of this case, and I will, at this point, put that on the record. Mr. Thompson's going to plead guilty to 1 count of attempted felonious assault. All remaining charges will be dismissed, and Mr. Thompson has been approved for drug court. I believe that is our plea agreement.
All right, Ms. Wagner, is that a complete and accurate statement of the plea agreement?
Yes, Judge.
Yeah, I apologize, Mr. Malero, I missed it. What is he pleading to?
He's going to plead guilty to an attempted assault, felonious assault, which will be an amended information count 6.
Okay, has an amended information been prepared. I don't see one.
Yes, Your Honor, I did send one a while ago, but I see that in the subject line of my email, I put a different defendant's name because I filed 2 this morning. But yes, I did file it. I can forward it again if I need to.
Yeah, if you could do that, I'd appreciate it.
Yes, I will.
It looks like you sent it to Miss Adams, Ms. Wagner.
Yes, and Francis and a couple other people, but I'll resend it right now. Judge, did you want me to send that directly to you?
That'd be fine.
Okay.
Okay, looks like we it just got handed to me, so we're all set.
Okay.
Okay, so Mr. Thompson, would you raise your right hand and let me know when you have it raised, please?
It's raised.
Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth under penalty for perjury?
Yes, Your Honor.
And you are Landon Mackay Thompson?
Yes.
Mr. Thompson, you've heard the statement of your attorney and the prosecuting attorney. Is it your intention to plead guilty today to count 6 on the amended information, attempted assault with a dangerous weapon?
Yes, Your Honor.
Do you understand that the maximum possible penalty for that offense is 2 years in prison and or a $1,000 fine?
Yes.
Are you satisfied with Mr. Malero and the advice he's given?
Yes, sir.
Neither the prosecutor, defendant, or anyone acting on the defendant's behalf has discussed a possible sentence with the court other than as we've discussed it on the record here today. Is that accurate, Ms. Wagner?
Yes, Your Honor.
Mr. Malero?
Yes, it is, Your Honor.
Is that also your understanding, Mr. Thompson?
Yes, sir.
If a guilty plea is accepted, there'll be no trial. That means you'll be giving up the rights that you would have had at trial. I'm going to explain those rights to you now to make sure that you understand them. You do have the right to a speedy public trial by jury. You could ask for a non-jury trial, and if the prosecutor and the court agreed, you could have a non-jury trial. You have the right to be presumed innocent until proven guilty beyond a reasonable doubt. You have the right to have the prosecuting attorney prove beyond a reasonable doubt that you are guilty and you do not have to prove anything. You have the right to be present at your trial, to have the witnesses against you appear at your trial, and to ask those witnesses questions. You have the right to have the court order any witnesses that you have for your defense to appear at your trial. You have the right to remain silent during your trial and not have that silence used against you. However, you also have the right to testify at your trial if you wanted to testify. Do you understand, Mr. Thompson, that if your plea is accepted, you may be giving up the right to appeal issues that would otherwise be appealable if you were convicted at a trial?
Yes, Your Honor.
Do you also understand that any appeal from the conviction and sentence pursuant to your plea will be by application for leave to appeal and not by right?
Yes.
If you are not a citizen of the United States of America, conviction of a crime can result in deportation, exclusion from admission to the United States of America, or denial of naturalization. Do you have any questions about any of those rights?
No, Your Honor.
Do you understand that you're giving those rights up?
Yes.
How do you wish to plead to the charge that on or about August 19, 2023 in the township of Madison, Lenawee County, Michigan, that you did commit the offense of attempted assault with a dangerous weapon?
Guilty with attempt.
I'm sorry?
Guilty.
Has anyone made any threats or promises to you to induce you to plead guilty to that charge?
No, Your Honor.
Do you understand that if I accept your plea, you're giving up any and all claims that your plea is given as a result of threats or promises that were not disclosed to the court on the record this morning, or that it was not your own choice to enter the plea?
Yes.
Is the prosecutor or defense counsel aware of any promises, threats, or inducements other than the plea bargain to induce Mr. Thompson to plead guilty?
No, Your Honor.
No, Your Honor.
Mr. Thompson, other than as we've discussed it on the record here this morning, has your attorney promised you any other particular sentence or estimated what your sentence would be?
No.
Is it your own choice to plead guilty today?
Yes.
Mr. Malero, would you like to establish the factual basis?
Yes, Your Honor. So Landon, is it true that on or about August 19th in the year 2023 that in the township of Madison, Lenawee County, state of Michigan, that you were involved with an altercation with a Ryan Thompson?
Yes, sir.
And Ryan Thompson is your uncle?
Yes.
And you attempted to assault him with a dangerous weapon? Is that true?
Yeah.
And that weapon happened to be a hacksaw?
Yeah.
And you did not intend to commit murder or inflict great bodily harm on your uncle?
No.
Just to assault him, yes?
Yeah.
And was substance abuse a factor in that matter?
Yeah.
Right. Is the state and the court satisfied, Your Honor?
I'm satisfied, Your Honor.
All right. Has the court complied with MCR 6.302 B, C, and D? Ms. Wagner?
Yes, Your Honor.
Mr. Malero?
I believe the court has.
All right. I will accept the plea then. It's been given understandably, voluntarily, and accurately. Mr. Thompson has had full knowledge of his rights. He has had competent counsel. Court's not made any agreement regarding the possibility of a plea or sentence in the case with the prosecutor, defense attorney, defendant, or anyone acting in the interest of any of them other than as it's been stated on the record this morning. I will refer the matter to the probation department for a pre-sentence investigation and set sentencing for July 18th at 8:15 a.m.
Your Honor, may we address an issue of bond?
Yeah, one second, Mr. Malero. Mr. Thompson, someone from the probation department is going to be in touch with you to do a pre-sentence investigation interview. When you do that interview, please be truthful about this offense and about your background.
Okay. Could you take?
Hold on.
All right. What is the bond issue you want to address, Mr. Malero?
Your Honor, Mr. Thompson's 20 years old. Now, I know there's a contempt issue out there from September, but he has been wearing a tether since April. He has now accepted responsibility for this matter. He has been in my office now all morning, patiently waiting for this matter. This is causing a financial hardship on his family and creating a problem for him to obtain employment. I'd ask the court if it would consider removing the tether requirement. I know in talking with him this morning, he is very excited and eager to begin the drug court program. So I don't think there's going to be an issue about any future attendance problems.
Ms. Wagner, anything you would like to say with respect to that request?
Your Honor, I don't have any objection to that. I would ask that there be some kind of substance abuse testing condition if that's not already in place.
All right. Okay, so what I'm going to do is modify Mr. Thompson's bond to remove the GPS requirement. I am also going to modify the bond to require him to start participating in the drug court program immediately, so even before sentencing. So he will need to get in contact with Sarah Teskey in the probation department to determine what the next step is for his participation there. And again, start attending all meetings, meeting all the requirements of the drug court program as a condition of his bond until the sentencing hearing. That will involve testing as well as a number of other requirements.
Thank you, Judge. Should he report then to Circuit Court probation right now? Well, you gotta go there.
Mr. Stevenson, is Ms. Teskey here today?
She's not here. She is
Okay.
not. Is he present?
He
Judge-
is at Mr. Malero's office over at the Public Defender's office.
Okay, I can talk to him if you want to put us in a breakout room, if that'll work.
Okay.
Yeah, we can do that.
All right, so Mr. Thompson, Mr. Stevenson is going to meet with you in a breakout session and collect your contact information. Make sure you give him good contact information because my assistant indicates that the mail we've been sending you has been coming back to us undelivered. So we need a good address for you. And Mr. Stevenson, if you could communicate that address information to Francis once you have it, I would appreciate that.
Yes, will do.
Okay.
Thank you, Judge.
Thank you. All right. And ma'am, you were Ms. Trammell, is that right?
Yes.
Okay. Your attorney is Mr. Malero?
Yes.
Okay, he's just dealing with one other client right now. As soon as he gets back here, I'll proceed with your case.
Okay.
Uniform for Wesley.
Transfer all the clean and stuff.
Could we have Leslie Cormigan for the judge, please? Thank you.
Also ready for. I just have to ask for regular.
Judge Olsen.
All right, good luck.
Thanks.
Okay. This is file 24-21839-AX, People versus Wesley Allen McCormick. We are here today for a hearing on an extradition file. We are proceeding today by video conference. Sir, you are Wesley Allen McCormick?
Correct. Yes, Your Honor.
All right.
Sorry, I'm short.
That's okay. So this is, there's been a request for extradition to the state of Ohio, Mr. McCormick, but you have a pending sentencing here in another case.
Correct.
Or I think it's like the first week of July.
July 11th, Your Honor.
July 11th. So
yes.
I guess a little bit of an issue with that, given that I don't want you to get sent to Ohio and then not be able to proceed with my sentencing here today or on July 11th. So I guess, well, let me go through a few things with you first. So this is a proceeding, Mr. McCormick, to determine whether you wish to waive your rights of extradition. Extradition is a proceeding to return you to another state in which a warrant has been issued for your arrest for the commission of a felony. It is in effect a demand by another state to return you to that state or for your surrender to return to that state to face the crime with which you've been charged in that state. You've been charged in the state of Ohio, in Wood County, with a probation violation for possession of marijuana.
Correct.
I presume that would be in a felony case that you're on probation for down there.
Yes, it is, Your Honor.
Okay, so we cannot, in the state of Michigan, determine the truth or falsity of the claims made against you in the state of Ohio. You are not required to waive your right to extradition. You can require the governor of the state of Michigan, I'm sorry, the state of Ohio, to demand upon the governor of the state of Michigan for a warrant for your extradition. You have the right to demand and procure legal counsel. If you can't afford an attorney, the court would appoint one for you at public expense. If you or your attorney wanted to test the legality of your arrest, you could apply within a reasonable time for a writ of habeas corpus. That's a writ by which your custodian is required to bring you before the court so that we can have a hearing regarding the legality of your arrest. Do you understand those rights, Mr. McCormick?
Yes, I do, Your Honor.
Would you like to be represented by an attorney?
Yes, please.
Okay. You have the ability to pay for your own attorney?
Not right now, no.
Okay. And you have, let's see. Okay, so I'm going to put you in a breakout session with Ms. Underwood from the Public Defender's Office, and you'll have a chance to speak to her right now. If you give me just a second.
Okay. Do I need to click something?
You should have something on your screen. Yeah, just click OK or yes or whatever. All right, and Mr. Malero, I believe this is Mr. Gregory in the Zoom pod at the jail. Do you need a breakout session with Mr. Gregory?
I do not, Your Honor.
So we are on the record in file 23-21584-FC, People versus Jonathan Andrew Gregory. We are here today in this case for a final pretrial conference We are proceeding today by video conference. First, let me have the attorneys place their appearances on the record, beginning with Ms. Arnold for the people.
Allison Arnold for the people.
Salvatore Malero on behalf of Jonathan Gregory.
All right, and so this is a final pretrial conference. We have a trial scheduled for June 25th through the 28th. So Mr. Malero, where do we stand with the case today?
Your Honor, at this point in time, we are confirming the trial date.
All right. So have you all submitted your jury instructions and voir dire questions?
Yes, Your Honor, you should have all that stuff. I think the only issue, Mr. Malero and I are planning on meeting tomorrow. I think we can discuss exhibits and see if there are any stipulations on exhibits and get those ready for the court. But I think other than that, we're ready to go.
Mr. Malero, are there any issues that we need to address from the defense side at this point?
Not at this time, Judge.
Okay. Do we have any audio visual stuff, video recordings, that kind of thing?
There's a video when the police first come and meet with the victim, Lucille Smith, and witness Annette, I forget Annette's last name. But there's a video that's going to be pretty brief. I think that might be the only video we're planning on playing. So other than that, I don't believe so.
All right. So I just asked you to come by the day before or get here early in the morning to hook it all up and make sure everything works properly so that we can get any technical issues resolved, hopefully beforehand.
Will do, Your Honor.
And then if there are any documents that you're going to be publishing to the jury, I would appreciate it if you could make a copy for each juror rather than have them have one read it and pass it around because that takes a lot of time when you do it that way.
Will do.
All right. Okay, so it sounds like we are all set for trial. Then we will proceed with that beginning on June 25th at 9 a.m.
Thanks, Judge.
Thank you, Your Honor.
Mr. Gregory, you can let the officer that's with you know that you are done with court for today. Mr. Malero, we have Ms. Trammell is here. Do you need to speak to her?
I do not.
Okay, let me take care of Mr. McCormick's case first, and then we'll do Ms. Trammell next. Okay, back on the record in file 24-21839-AX. Ms. Underwood, do you want to place your appearance on the record?
Rhonda Underwood for Mr. McCormick this morning. Thank you, Your Honor.
And you know how Mr. McCormick wants to proceed today?
Mr. McCormick in this matter is eager to get back to Ohio and take care of it with all possible dispatch, Your Honor. He has agreed to waive any objection.
All right. So again, I've got a concern that if we extradite him right now, I'm not going to be able to find him for our sentencing on July 11th. Is there any objection if I adjourn the hearing on the extradition to July 11th and we finish the extradition issue up at that time, and then we'll have.
Well, I believe Ms. Dumont. Oh, sorry.
I'm sorry. Go ahead.
I apologize, Your Honor. I believe Ms. Dumont represents him on that case, Your Honor, and I believe she would be fully capable of finding out where, if he is still incarcerated in Ohio, he is, that a sentencing could be conducted.
That's correct, Your Honor. Ms. Dumont is representing me for the other case. And her and my attorney down there are working together, so they're in contact too.
All right, Mr. McCormick, then, did they give you copies of a waiver of extradition form?
All I've got is my piece of paper saying I have court today. That's all I've gotten.
Okay. Can you get somebody's attention over there? They should have 4 copies of a waiver form that you need to sign while we're on the record.
Yep. Give me 1 second. I'll pop my head up.
Yeah,
Excuse
okay.
me. Yeah, I need a copy of the extradition. Something about 4 paperwork I need to sign. Something about the copyright or the copies of the extradition form. Something 4 papers. You want to? Here, do you want to talk to waiver? Yeah, the waiver. Yep, he's grabbing it right now, Your Honor.
Okay.
They're looking for it. Yeah, I'm really just trying to get down there and get this taken care of, and then, come back to your courtroom and get everything taken care of here and just better my life. That's all I want to do.
Okay.
Got a lot of really good opportunities lately for my career, so ready to move forward with those.
Have they brought you those papers yet, Mr. McCormick, or no?
They haven't. They're still trying to find them, I think.
Okay. I'm just going to pass your case so I can get working on another one, and I'll get back to you as soon as you have that stuff. So.
Okay, sounds good.
Mr. Malero, you ready to proceed with Ms. Trammell?
Yes, I'm ready, Your Honor.
Okay, this is file 23-21467-FH, People versus Tora Nicole Trammell. We're here today for a pretrial hearing in this case. We are proceeding today by video conference. First, let me have the attorneys place their appearances on record, beginning with Ms. Wagner.
Thank you. Amanda Wagner for the people.
Salvatore Malero on behalf of Tora Trammell.
All right, and Mr. Malero, where do we stand with Ms. Trammell's case today?
Your Honor, I believe we have a resolution of this matter. Ms. Trammell is going to plead guilty to an amended information, which I presume the court has, to a count 2, possession of cocaine, a 4-year felony, count 1, subsequent offense notice, and the habitual offender notice will be dismissed.
All right, Ms. Wagner, is that a complete and accurate statement of the plea agreement?
Yes, it is, Your Honor.
All right, Ms. Trammell, would you raise your right hand, please? Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth under penalty for perjury?
Yes.
And you are Tora Nicole Trammell?
Yes.
Ms. Trammell, you've heard the statement of your attorney and the prosecuting attorney. Is it your intention to plead guilty today to count 2 on the amended information, possession of cocaine less than 25 grams?
Yes.
Are you satisfied with Mr. Malero and the advice that he's given?
Yes.
You understand that the maximum possible penalty for that offense is up to 4 years and in prison and or a $25,000 fine.
Yes.
Neither the prosecutor, defendant, or anyone acting on the defendant's behalf has discussed a possible sentence with the court. Is that correct, Ms. Wagner?
Yes, Your Honor.
Mr. Malero?
Well, not with this court. This is Judge Anzalone's case, Judge. And there were some discussions about sentencing, but nothing was determined.
Okay, so there's no agreements with respect to this sentence. Is that correct?
That is correct.
Is that also your understanding, Ms. Trammell?
Yes.
If a guilty plea is accepted, there'll be no trial. That means you'll be giving up the rights that you would have had at trial. I'm going to explain those rights to you now to make sure that you understand them. You do have the right to a speedy public trial by jury. You could ask for a non-jury trial, and if the prosecutor and the court agreed, you could have a non-jury trial. You have the right to be presumed innocent until proven guilty beyond a reasonable doubt. You have the right to have the prosecuting attorney prove beyond a reasonable doubt that you are guilty, and you do not have to prove anything. You have the right to be present at trial, to have the witnesses against you appear at your trial, and to ask those witnesses questions. You have the right to have the court order any witnesses you have for your defense to appear at your trial. You have the right to remain silent during your trial and not have that silence used against you. However, you also have the right to testify at your trial if you wanted to testify. Do you understand, Ms. Trammell, that if your plea is accepted, you may be giving up the right to appeal issues that would otherwise be appealable if you were convicted at a trial?
Yes.
Do you also understand that any appeal from the conviction and sentence pursuant to your plea would be by application for leave to appeal and not by right?
Yes.
If you are not a citizen of the United States of America, conviction of a crime can result in deportation, exclusion from admission to the United States of America, or denial of naturalization. Do you have any questions about any of those rights?
No.
Do you understand that you're giving those rights up?
Yes.
How do you wish to plead to the charge that on or about May 31st, 2023 in Franklin Township, Lenawee County, Michigan, that you did commit the offense of possession of cocaine of less than 25 grams?
Guilty.
Has anyone made any threats or promises to you to induce you to plead guilty to that charge?
No.
Do you understand that if I accept your plea, you're giving up any and all claims that the plea was given as a result of threats or promises not disclosed to the court on the record this morning, or that it was not your own choice to enter the plea?
Yes.
Is the prosecutor or defense counsel aware of any promises, threats, or inducements other than the plea bargain to induce Ms. Trammell to plead guilty?
No, Your Honor.
No, Your Honor.
Ms. Trammell, has your attorney promised you any particular sentence or estimated what your sentence would be?
No.
Is it your own choice to plead guilty?
Yes.
Mr. Malero, would you like to establish the factual basis?
Yes, Your Honor. So, Ms. Trammell, is it true that on or about May 31st, 2023, in Franklin Township, County of Illinois, State of Michigan, that you were in possession of a controlled substance, cocaine, less than 25 grams?
Yes.
And you knew you were in possession of that controlled substance?
Yes.
And you didn't have any legal right to be in possession of that controlled substance. Is that true?
No. Yes, that's true.
Okay. Is the state and the court satisfied, Your Honor?
I am satisfied, Your Honor. Thank you.
All right, has the court complied with MCR 6.302 B, C, and D, Ms. Wagner?
Yes, Your Honor.
Sir Malero?
Yes, I believe the court has.
Okay, I'll accept the plea then. It's been given understandably, voluntarily, and accurately. Ms. Trammell's had full knowledge of her rights. She has had competent counsel. The court's not made any agreement regarding the possibility of a plea or sentence in this case with the prosecutor, defense attorney, defendant, or anyone acting in the interest of any of them. I will refer the matter to probation department for a pre-sentence investigation. We'll need a sentencing date with Judge Anzalone. Francis, do you have a sentencing date for Judge Anzalone?
August 8th at 8:15.
So August 8th at 8:15 a.m.
Okay.
All right, Ms. Trammell, I'm going to put you in a breakout session with Mr. Stevenson from the probation department so he can collect your contact information.
Okay.
And when you're done talking to Mr. Stevenson, you're done with court, so you can exit out of the meeting directly from that breakout session if you like.
Okay.
When you do your pre-sentence investigation interview, please be truthful about the offense and about your background.
Okay.
Thank you, Your Honor.
Thank you, Your Honor.
Okay. Thank you, Mr. Miller and Ms. Wagner. Okay, so Mr. McCormick, I think I saw someone bring you those forms. Is that right?
Yes. Yep. I got them right here, Your Honor.
Okay. So back on the record in file 24-21839-AX, People versus Wesley Allen McCormick. So Mr. McCormick, do you want to waive your rights to extradition to a writ of habeas corpus and go voluntarily to the state of Ohio to face the charges made against you in that state?
Correct.
All right, so please sign then those waiver of extradition forms. You need to sign each one in about the middle of the page above the line that says signature.
Your Honor, he only gave me one sheet. I don't know if you see, it's just this one that he gave me.
Okay, I guess if they only gave you one, just sign that one then.
Okay, yep, it's all signed.
All right, do you swear that the signing of that document is your own free act and deed for the purpose of waiving extradition?
Yes, I do, Your Honor.
All right, so what will happen next then is they'll bring that over to me. There's a certification for me to sign. I'll sign that today. Then they'll contact the people in, what was it, Wood County, and let them know
yes.
that you're ready to be picked up, and then they'll come and get you.
Okay, do you know roughly how long that takes?
I do not know how long that takes. Probably the people at the jail might have a better idea.
Okay, thank you very much, Your Honor. I appreciate it.
All right, so you are all set with court for today.
Thank you.
All right, so well, I can go to jail.
Am I good to go then?
Yeah, I'm sorry, Mr. McCormick. You're all set. You can
okay.
You're free to go.
Okay, thank you very much. Have a good day, Honor.
Warrant was returned yesterday, so. Signing bonds. What I get wrong names. Douglas clerk, I just repeat clerk. So never mind. Okay, Ms. Underwood, we're calling for Douglas Clark right now.
Do we also have a Mr. Skupak on the docket, Your Honor?
Not that I'm aware of.
Okay, maybe
What
that
was
was
that?
dismissed.
What was the name?
It was a Tyler Skupak. SCHUP.
Yeah, I know who, I recognize that name. Let me try to look him up and see.
I'm sorry?
Let me try to look him up. Just give me a second here.
That might have been dismissed somewhere along the line. I'm thinking maybe.
I think you might be right about that. I think that was relative to a divorce action, and I think that got taken. How do you spell that? SCHUB?
SCHUPBACH.
That was a PPO.
I'm sorry, it was a PPO. And he said it was supposed to be dismissed pursuant to.
Yeah, yep. We put a plea, or not a plea agreement, we put a, they had a mediation with in the divorce action. We put that agreement on the record. Part of that agreement was to dismiss the PPO violation. So
thank you.
Okay.
Then Mr. Clark would be my last, I think.
Okay. And Mr. Hackett, did you?
Yes.
Oh, I'm sorry. Oh.
Thank you, Mayor Pro.
Yep.
Thank you, Judge.
Thank you very much.
I'll file this with the court.
Great, thank you.
Thank you, Judge.
Oh, yeah, sorry, Mr. Malero, you're all set. Have a nice day.
Thank you, Judge. You too.
I'm gonna need some meds. I'll take it.
I think I already sent this over.
He's got a motion on Monday.
Sure. Sign this up.
That must not have been filed yet.
is Elias Monk. Okay, so we are on record now in files 22-20842-FH and 22-20843-FH versus Douglas Wayne Clark. We are here today for arraignment on bench warrants in both of those cases. We are proceeding today by video conference. Sir, you are Douglas Wayne Clark?
Yes, sir.
Mr. Clark, have you received copies of the warrants?
Yes, sir.
Okay. The warrants allege that you violated the conditions of your probation by failing to appear, I'm sorry, that not I apologize. I had a brain mistake. I don't know if I said bond conditions, but if I did, it was a mistake. The warrant alleges that you failed to appear for a probation violation hearing on November 15th, 2023, in each of those cases. The underlying summons for a probation violation alleges that you violated the terms of your probation by failing to report on October 24, 2023, and by failing to report to treatment court on October 26, 2023. In file 22-20842-FH, you had originally pled guilty to possession of controlled substance of less than 25 grams, and the maximum possible penalty for that offense up to 4 years in prison and or a $25,000 fine. In file 22-20843-FH, you had originally pled guilty to larceny from a motor vehicle, and the maximum possible penalty for that offense is up to 5 years in prison and or a $10,000 fine. You do have, and I'm sorry, on the failure to appear part of it, which would be a contempt of court, the maximum penalty for the failure to appear would be up to 93 days in jail and or $7,500 fine. You do have the right to be represented by an attorney today, Mr. Clark, at this hearing and at any hearings that we might have on this matter. If you cannot afford an attorney, you can tell me that now and I'll appoint one for you at public expense. Do you understand that?
Yes, sir.
Would you like to be represented by an attorney?
No.
Do you understand that you have a right to contest the contempt of court charge and to have a trial on it?
Yeah.
Do you understand that throughout that trial, you would be presumed innocent until your guilt is proven beyond a reasonable doubt?
Yes, sir.
Do you understand that with respect to the violations of probations, that you also have a right to a trial on those?
Yes, sir.
And do you understand that throughout those trials, you would be presumed innocent until your guilt is proven by a preponderance of evidence?
Yes, sir.
With respect to any trial that we might have regarding the contempt or the alleged probation violations, you would have the right to have all of the witnesses against you appear at your trial. You or your lawyer, if you had one, could ask those witnesses questions. And you also have the right to have me order any witnesses that you have for your defense to appear at your trial. Do you understand all of that?
Yes, sir.
You are not required to testify at your trial, and no one can say anything about you not testifying or hold that against you in any way. Do you understand that?
Yes, sir.
On the other hand, you understand you have the right to testify at your trial if you wanted to testify.
Yes, sir.
How do you want to plead to the charge that you committed contempt of court by failing to appear for a court hearing?
Guilty.
And how do you want to plead to the charge that you violated the conditions of your probation by failing to report to your probation officer and failing to report to treatment court?
Guilty.
Do you understand that by pleading guilty, you're giving up your right to a trial and your right to have your lawyer's assistance at that trial, as I've already explained?
Yes, sir.
Has anything been promised to you in order to plead guilty?
No, sir.
Has anybody threatened you in any way in order to get you to plead guilty?
No, sir.
If I accept your pleas, you'll be giving up any and all claims that the pleas were given as a result of threats or promises that were not disclosed to the court on the record this morning, or that it was not your own choice to enter the plea. Do you understand that?
Yes, sir. I just want to be done with this stuff.
Okay. Is it your own choice? Is it your own choice to plead guilty today?
Yes, sir.
Okay. So you have previously been on probation in both of these files, is that right?
Yes, sir. I've already served 9 months. Already got 9 months time served.
All right. And as a part of your probation, were you required to report to your probation officer as directed?
Yes, sir.
And were you also involved in a treatment court?
Yes, sir. I was in drug court.
Okay. And did you fail to report to your probation officer back on October 24, 2023?
Yes, sir, I did.
And did you also fail to go to the drug court meeting on October 26, 2023?
Yes, sir, I did.
All right. And so as a result of that, your probation officer or the Judge Angelo, who normally has your case, issued a summons for you to appear for a court hearing on November 15, 2023. Did you fail to appear for that hearing?
Yes, sir, I did.
I will accept your pleas then. They've been given understandably, voluntarily, and accurately. Mr. Clark has had full knowledge of his rights to competent counsel. I will refer this matter to the probation department, and we can set sentencing for June 21st at 8:15 a.m. Although, Mr. Clark, I will advise you, so your cases are normally handled by Judge Angelo. I did the arraignment today because she is out today. You have the option to go back to Judge Angelo for your sentencing hearing and have her handle it. Or you also have the right to have me do the sentencing hearing since I did the arraignment. Do you know how you want to proceed with that?
I know I'm looking at prison time, but I've got 9 months served on these already. How much time do you think I'll get?
I don't have any idea because I don't know. It's Judge Angelo's case, so I don't know any of the facts of your circumstances, and I don't have. Obviously, the probation department is going to do an update of your pre-sentence investigation, and they'll make a recommendation. But I just don't have any idea to be able to tell you right now, Mr. Clark.
It don't matter, I guess. I don't know. I probably should have took out a lawyer, I guess. I don't know.
I'm sorry?
I probably should have got a lawyer. No.
Do you want to speak to one now?
Yes, please. Yeah.
All right.
I do. I'm sorry.
Okay. Do you have the ability to pay for your own lawyer?
I do not.
Okay, so I'll put you in a breakout session with Ms. Underwood from the Public Defender's Office.
Your Honor, before I talk to Mr. Clark, just so I know, when is Judge Angelo back?
she'll be back next either Monday or Tuesday. So she's here next week.
I'm sorry?
She'll be back Monday or Tuesday of next week.
Oh, okay. So he could have sentencing either way.
Yeah, that would not, that I don't think would delay sentencing.
Okay. I'll speak to Mr. Clark now.
Okay. Okay, we have Mr. Clark and Ms. Underwood back from the breakout session. Ms. Underwood, do you know how Mr. Clark wants to proceed today?
Yes, Your Honor. I believe Mr. Clark, Judge Angelo knows the most about the case, Your Honor. So I believe Mr. Clark should probably go back to her for sentencing. If we could have that scheduled for the 21st, I believe, or.
All right, so I'll set it for sentencing on the 21st. That'll be before Judge Ansel.
Thank you, Your Honor.
Thank you, sir.
Okay, Mr. Clark, you can let the officer with you know you are done with court for today.
All right, thank you.
Your Honor, I believe that's everything.
Yep, and we are all set. Thank you.
Thank you.